Welcome to our law firm. We hope we can assist you with this very difficult situation. We have prepared this brief presentation to educate you as to what you may expect during the dissolution of marriage or divorce process. In the event you wish to proceed with the divorce, this presentation will serve as a roadmap as to what you can expect from the court regarding the divorce process. Please take notes of this video. Take notes as if you were going to teach this information to someone, as the information contained within this video will serve to answer many, if not all of your questions. So let's start with the proposition of no-fault divorce. Florida is a no-fault divorce state. So what does that mean? Make no mistake, this is a lawsuit. You are suing your spouse, or your spouse is suing you for divorce. About 20-30 years ago, it used to be you had to put on evidence in court and prove that your spouse cheated on you, abused you, abandoned the family, failed to support the family. And you had to prove it. How do you do that? If you remember the old black and white movies back in the 50s and 60s, you would see a couple walking into a motel in the night, and then in the background, a guy slouched down in a car taking photographs of the couple. Why? They were gathering evidence to prove they were having an affair, right? Well, we don't have to do that anymore. All you have to do is go to court and under oath tell the judge that your marriage is irretrievably broken and cannot be fixed. Let's talk about assets and money. Florida is what's known as an equitable distribution state. So what does that mean? That means we use the word equitable. Equity means what's fair. Would it be fair if you have $100,000 in your IRA and you were to get married today and your spouse files for divorce tomorrow? Would it be fair that your spouse receive half of the IRA, or $50,000? Of course not. So what we mean by equitable distribution is what's fair. So generally speaking, so long as you do not commingle assets, anything you bring to the marriage is yours. Anything that was accumulated during the marriage is generally divided 50-50. So for example, you're married in 2001 and you file for divorce in 2021. Let's say in 2001 you had $100,000 in a 401k. And the value of the 401k grew over those 20 years to $500,000. So as you can see, there is $400,000 of appreciation. In this situation, the court would say, okay, you get the first $100,000, but then you have to equally split the appreciation of $400,000 with your spouse. So you would get the first $100,000, which is premarital, plus 50% of the appreciation, or $200,000, for a total of $300,000, and your spouse would get $200,000. The same principle applies to liabilities. So if there's $25,000 in credit card debt, or even student loans that was accumulated during the marriage, there could be a claim that each spouse is responsible for half, or $12,500, even if the credit card or loan is in just one spouse's name. Keep in mind things like an inheritance or personal injury claim are not subject to division within the marital estate unless the funds are commingled with marital funds. Courts have what's called a status quo order, where when a divorce is filed, the courts want the parties to maintain the status quo. So for example, if you were making payments on the mortgage, paying the utilities and car payments and so forth, the court is going to want you to continue to do that until everything gets sorted out. The next issue is where you could be asked to pay your spouse's attorney's fees. But again, like alimony, it's based on a need and an ability to pay analysis. Let's assume that you're not liquid, and neither is your spouse. So a judge may, if there's a hearing on it, might order attorney's fees, or the judge might say, I'm going to reserve until trial, which means your spouse has a good claim for attorney's fees. The judge may go on to say, I'll hear the attorney's fees issue at trial at the end of the case. That's unlikely when it comes to attorney's fees because there's so much work to do to get to the trial. A well-seasoned attorney will not take your case without being paid. But sometimes a judge will order a spouse to liquidate a retirement account if the judge believes that you've been playing dirty. So let's talk about how a case goes through the system. Let's assume your spouse has filed a petition for dissolution of marriage and you've been served. Currently, you're meeting with your attorney. you're discussing some of these strategies. Let's assume, for example, you hire our firm. We're then going to file an answer and counter petition for the dissolution of marriage. Your spouse has already filed a petition. You're going to file an answer and counter petition. In order to get something, you have to ask for it. Your spouse has already asked for everything that they want in their petition. So if you just file an answer, you wouldn't get anything because you haven't asked for anything. So you have to file a counter petition along with the answer so that you can get something, whether it be equitable distribution, time sharing, custody and visitation, child support, or alimony. So we have to file a counter petition on your behalf and then serve your spouse's attorney with it. And then your spouse's attorney will file an answer to that counter petition. So your spouse serves you and you must respond within 20 days. If you don't respond, your spouse will default you and move forward without you by filing a motion for default. Your spouse will prepare a financial affidavit, take a parenting education class, and run the child support guidelines if children are involved, and then go to a final hearing and obtain a judgment without you. However, if you're watching this video, you're going to respond. Let's go this way. The first thing we need to do is compile and exchange mandatory disclosure. Mandatory disclosure consists of a financial affidavit and supporting documentation. We would be completing a financial affidavit on your behalf. However, you would be providing us with the information and documentation. The financial affidavit is a statement of your income and expenses, assets, and liabilities. That must be provided to your spouse along with 3 years of income tax returns, pay stubs, loan applications and financial statements, leases in your name, financial account statements, bank account statements, retirement accounts, plan descriptions, virtual currency accounts, the declarations page for any life and health insurance policies, corporate, partnership, and trust tax returns, a copy of all credit card and charge account statements, any lease agreements, such as an apartment or car lease, a copy of a pre- or post-nuptial agreement that may exist. Generally, you have 45 days to put all that together and get it to your spouse, and your spouse has 45 days to put it together and get it to you. Once we have mandatory disclosure, we can look at the financial statement and then reconcile the numbers in the financial statement with the numbers on the documents. That's what's called discovery. Now, let's say, for example, your spouse does not want to comply with mandatory disclosure or does not want to turn over a bank statement or a tax return. Then we would file a motion with the court to compel your spouse to provide the required documents. The judge would issue a court order ordering your spouse to turn over the documents within a certain amount of time, usually 14 days. That's the motion to compel. Also, you can go further in the discovery process and serve your spouse with interrogatories, requests for documents, requests for admissions, and even take depositions. In many cases where both spouses are W-2 employees, this is not necessary. Some attorneys will do it. Once the discovery is complete, and by the way, this is where you would consider whether to hire a vocational expert to examine your spouse as to their ability to enter the workforce, a forensic accounting expert to find hidden money or determine the value of a business, a psychological expert in the event your spouse may be exhibiting irrational behavior and children are involved, and so on. In the meantime, you can go into court on motions for temporary orders, such as temporary attorney's fees, temporary alimony, temporary child support, among other things. Temporary meaning during the litigation of the case. Once we've completed discovery, we can then enter into informal settlement negotiations with your spouse or your spouse's attorney. If we can't settle, then we can go to mediation. Mediation is where both of you come together, sit at the table to try and resolve your differences. As a practical matter, we use 2 conference rooms. We're in one room with you, and your spouse is in the other room with their attorney. And then we have the mediator, who is a third-party neutral, usually an attorney with family law experience, with no interest in your case and no skin in the game. The mediator will go back and forth between the 2 rooms. This tends to increase the chances of a settlement in that both spouses don't feel uncomfortable sitting across the table looking at each other, or whether one spouse may intimidate the other, and so forth. Very important, please keep in mind that you do not want to go to mediation without completing the discovery process. Think about it. How can you settle with your spouse of, say, 15 years, not knowing what they have? Further, you do not want to go to mediation without an attorney. Why? Because a mediator cannot advocate for either of you. The mediator cannot make arguments for or against you or your spouse's position. A mediator cannot give you legal advice. This is not the time to cheap out on an attorney, especially when your future and the future of your children are at stake. To start, the mediator will probably start with the spouse who filed for divorce. That spouse will tell the mediator everything the spouse wants. Then the mediator will go to the other spouse and ask that spouse what they want. The mediator will go back and forth until there's a resolution. Keep in mind that a mediation can go 4, 8, 10 hours and could even go on for days. If the mediator cannot bring the two of you to an agreement, the mediator will file a notice with the court informing the court of an impasse, and then you will go to trial. If the mediator is successful and you sign a settlement agreement at the mediation table, you're as good as divorced. The next step is simply to go into court, present all the paperwork to the judge. The judge will make sure all the paperwork is in order and issue the final judgment of divorce. Next, let's talk about legal fees and costs. Most seasoned family law attorneys bill hourly at a rate of between $350 and $600 an hour. And they will bill in increments of 6 minutes or tenths of an hour. You're billed for the attorney's time. You're billed for phone calls, email, document preparation, text messages. You'll be billed any time that the attorney works on your file. Generally, and very important, if you've got 10 questions, don't call or email your attorney 10 times with 10 separate questions. Call or email once with 10 questions and you'll save a whole lot of money. You won't have to worry about sticker shock when you receive that first invoice. Now, this is what an invoice looks like. It shows you what we did, when we did it, and how long it took to do it. For example, we prepared the petition for dissolution of marriage. We spent 9/10 of an hour doing it, multiplied 0.9 times our hourly rate, and the cost in this example is $382.50. So, we add up our time. Then we add up the expenses. Again, in this example, the legal fees total $765. Regarding the costs, we paid a filing fee of $409, service of process $50, and the summons fee is $10. These three costs are a one-time cost. Then we charge for postage, copies, legal research database fees, and so forth. We take our total time, $765. We add it to the total cost of $528.54 for a total of $1,293.54. In this example, the retainer deposit is $5,500. We then take the total amount and subtract it from the retainer, and you'll see there is a $4,206.46 credit, which will go into the next month. We send these invoices on a monthly basis. You'll have it no later than the 5th day of any month, showing you what we did, when we did it, how long it took to do it. We ask that you take up to 30 days to review the invoice. If we do not hear from you of any inaccuracies, we'll assume that the invoice is accurate. So, how much is your divorce going to cost? Can you give me a rate? Can you ballpark me an estimate? Well, it's difficult. Is it going to cost more than $5,500? Most likely, yes. Invariably, clients want to know how much a divorce will cost, and rightfully so. Please keep in mind that it's virtually impossible to predict the cost of a domestic relations case. This is why experienced, well-seasoned lawyers only bill on an hourly rate basis, not a flat fee basis. Why? Because of the many unpredictable variables. We can't predict the actions of your spouse. We can't predict the actions of your spouse's attorney. We don't even know who your spouse's attorney is. We cannot predict the actions of the court. We don't even know who the judge is yet. This is why you're billed on an hourly basis. How long is this process going to take? Great question. Again, a lot of different variables and a question that is impossible to predict. However, if both spouses agree to everything, and I had all the paperwork tomorrow, signed, sealed, and delivered, I can have you divorced in 4 to 6 weeks. Otherwise, with disputes and arguing, the process could take anywhere from 3 months to 2 years or more. It's all about how the spouses work with each other and the lawyers as well. but most important is the cooperation between the spouses. Please keep in mind that the driving force behind the amount of money your case is going to cost and the time it takes is the level of anger that you have for each other. That's what drives these cases, anger. If you can control your anger, you can control the costs and the amount of time and money to get to the finish line.